Bismillahirrahmanirrahim. In the light of the most competent economists of Pakistan, the main reason for the destruction of economical system of Pakistan is corruption and misappropriation in the tenders and the work projects. And if this process would have been completed and done transparently, 85% corruption will be eliminated from Pakistan. Therefore, today's lecture is regarding public procurement regulatory authority and the laws, bylaws and rules of it. My name is Ghulam Sajjad Gopang. I am MBA Finance first position holder from IBA University of Sindh Jamshoro. I am LLB first position holder from Qazi Azam Law College Nawab Shah Sindh. I am the first advocate Supreme Court in the history of Nawab Shah Bar Association, and I am the youngest advocate in the history of Supreme Court of Pakistan. I am mainly practicing at Supreme Court Islamabad, having more than 1000 cases at Supreme Court and more than 100 cases reported in PLD law books of Pakistan. My most famous cases reported in Supreme Court cases are 2019 SCMR 2063 and the other one is PLD 2020 Supreme Court 293. First, PPRA ordinance was issued in 2002. Secondly, PPRA rules issued in 2004, then PPRA regulations in 2008, 2009, 2010, and finally extraordinary published this rule on Tuesday 29th June 2021. And mainly 5 categories were inserted: blacklisting, clarification grounds, and the definition of corruption and the fraudulent practices was also inserted. 5 categories have been defined. Number 1 is coercive parties, the parties which are threatening, those companies can be blacklisted. Number 2, collusive practices, arrangements between 2 or more parties. If any bid or any process is managed to disclose, stifle the open competition, a game is played in it, then that party can be blacklisted. Number 3 is corrupt practices, offer of any kind or illegal gratification. If it is proved, then again company will be blacklisted. Number 4, fraudulent, if any misrepresentation is made by the company. And number 5 is obstructive practices, means threat during process or after the process, when the execution is being done, when the contract is done. These 5 categories are inserted in which the companies can be blacklisted. Amendments in rule number 10, specifications, 5 clauses are substituted in it. Amendment in rule number 19, again blacklisting and debarment. If any company is proved to be involved in fraud and misrepresentation and corrupt practices, that company can be banned for 10 years, up to 10 years. Can be less than that, not more than that. And if the company is failed to fulfill the conditions promised by that in that process of contract and during execution, that company can be banned for blacklisted for 3 years. but after the decision of appellate authority, and I will define what appellate authority has been provided here. And then is, if during bid security declaration, if company is failed, then 6 months will be the period for which that company can be banned or blacklisted. And the second point is that the company regarding that blacklisted will be communicated. And number 3 is bidder may file review petition. This is something which is first time inserted in it. Regularly, I have more than 1000 cases of PPRA rules pending at High Court, Islamabad High Court and the Honorable Supreme Court. We and other lawyers used to challenge the orders of PPRA in writ jurisdiction, but now they have provided in new amendment, new rules, new regulations, new ordinance. A review authority has been created, and the if anyone is aggrieved from the blacklisting, you can file review within 30 days. This is the limitation. 30 days from the date of communication, the date when he is informed the order is communicated to him. The company can file review petition in 90 days, and the reviewing authority will have to decide it in 90 days. And the decision of review authority will be final, so there will be no any appellate authority, and that order can be challenged in writ jurisdiction. Number 4 is, if the bidder is blacklisted by a foreign country, international organization or foreign institution should be treated as blacklisted for all the international contracts in Pakistan. But in case of public sector, board should have the power to review that. Number 5 is that this blacklisting will not apply on ongoing projects. This is very important. If your company is blacklisted and the review is dismissed in October 2021, but before that, few days before or few months before, you were allowed for another contract in another project or in the same company, this blacklisting will not apply on ongoing projects, but you are already been awarded if you are already in a contract. This will apply after that for, as I have described, for 10 years, 6 months or 3 years. Number 5 is this blacklisting will not apply on ongoing public contract in which the bidder is already engaged, and section 35 is also substituted, and that is announcement of evaluation reports. Acceptance or rejection must be announced within 15 days. This is also a new amendment. Prior to award of procurement of contract, 15 days prior to the award of procurement of the contract. And then Rule 38A is omitted from that. Rule 41 is confidentiality. Confidentiality is also a very important inserted rule, and Rule 42E is also very important, in which 6 clauses will be inserted and are inserted. If the value of procurement is up to 200 millions, then the procurement agency can utilize forced account. This is a very important insertion, and if anything is proved doubtful in it, there will be several writ petitions filed against this, and if it is made transparently, then it will be in the interest of our country. Now, in what situations, in what categories it can be done? Number 1 is if the works are in small nature, small works. Number 2 is ongoing operations. For ongoing operations, it can be the procurement agency can utilize forced account. Number 3 is if the projects are urgent in nature, just like repairs, urgent repairs. And number 4 is unavoidable risk. If the project is all the projects are extremely necessary, but if procurement agency feels that we cannot take any risk, then it can utilize this. And number 5 is in extreme emergencies. If the procurement agency feels extreme emergency, then again it can be used. And number 6 is if the project is of sensitive nature and its information cannot be shared with private sector. This is a very, very important clause, and again I repeat that if it is not practiced transparently, there will be several writ petitions filed against this clause. And if it is done transparently, then it is very nice. We will welcome it. It is further clarified that provided that the state-owned entity engaged for procurement shall accomplish the task exclusively through its own resources without involving private sector as partner or joint venture or subcontractor. Again, a very important amendment, and it will be checked. And then comes the direct contracting with the state-owned entities. 5 clauses are inserted in it. 48 are, Rule 48 says redressal of grievance. This is very important, that if the any company is aggrieved and feels that they have been wrongly and illegally blacklisted, what are the legal remedies for them? 7 clauses have been substituted. Number 1 is that procurement agency shall constitute a committee in odd numbers of persons to address the complaints of bidders prior to entry into force of procurement contract. That company will be Grievance Redressal Company, GRC. This is the company that if the bidders have any complaints, this is the duty of Grievance Redressal Company to redress their grievance and decide expeditiously. Number 2 is that GRC, Grievance Redressal Company, shall address the grievance well before proposal submission deadline. If the proposal submission deadline is 28th October 2021, it is duty of GRC to decide that complaint, to redress that complaint on either way, in accordance with the law and the rules, well before that deadline. Number 3 said any bidder may lodge with the complaint after submission of his bid within 7 days of announcement of technical evaluation report, TER, and 5 days after issuance of the final evaluation report, 7 days before announcement of technical evaluation report, and 5 days after issuance of final evaluation report. Number 4 says that in case the complaint is filed against the technical evaluation report, TER, the GRC shall suspend the procurement proceedings. This is very, very important, that if any such complaint is filed and the deadline is very near, that bidder, that company shall be given full chance, full opportunity to prove that that company is eligible for the procurement, for the tender, and shall rights should not be violated. I repeat, in case the complaint is filed against technical evaluation report, the GRC shall, it is said shall, not will, not may, shall suspend the procurement proceedings till the decision of it. In case the complaint is filed after evaluation report, in case the complaint is filed after final evaluation, the complaint cannot raise any objection on technical evaluation report. Now, if the complaint is not filed during that process, it is filed after the final evaluation report, then that previous technical evaluation report cannot be challenged in that, provided that the complainant may raise objection on any part. Complainant may raise any objection on any part of the final evaluation report in case where single stage, single envelope bidding process is adopted. If this process is being done, if this procedure is adopted, single stage, single envelope bidding process is adopted, then it can be done. And this single envelope, single stage, single envelope process procedure is defined in 2020 CLD page number 51 Islamabad High Court and 2012 CLD 1445 and 2012 CLC 1434. The Honorable High Courts have defined it, and it is relating to 36A PPRA Rule 2004 and the Central Vigilance Committee. Number 6 is GRC shall investigate and decide the complaint in 10 days. The time to decide such complaint for GRC, Grievance Redressal Committee, is 10 days. And number 7 is any bidder can challenge that decision of GRC. Now, first you have applied for that bidding. If you have been knocked out, you can challenge before GRC. GRC will have to decide it within 10 days, and if the GRC has maintained the decision and GRC have knocked you out, have dismissed your complaint, then you can challenge the decision of GRC. Any bidder can challenge the decision of GRC through an appeal before the competent authority within 30 days. Then you will have 30 days. Now the process which has been changed is that this authority has been inserted. If you are aggrieved, then you can approach GRC, and if the Grievance Redressal Committee has also dismissed your complaint, then you have the final remedy within 30 days of communication of the order of GRC. Any bidder can challenge the decision of GRC through an appeal before the authority within 30 days of communication of the decision. Authority's decision will be final. So after that competent authority decision, you can challenge it before High. In this regard, a very important decision of PLD 2013 Islamabad High Court page number 85 was that process was not followed, and the National Logistics Cell, which is a very important organization and very powerful as well, and you know why National Logistic Cell is important and powerful, you know very well. So the MOU between the government and LLC was declared illegal by Islamabad High Court and was disqualified. The eligible bidders were disqualified illegally, and Islamabad High Court declared that this MOU is illegal between NLC and the government, and the contract which was awarded to NLC was declared illegal and it was set aside, and the government was directed to refund the amount which was paid by NLC, and the matter was referred to National Accountability Bureau (NAB) authorities to investigate into the matter. Then foreign funding projects judgment is 2021 CLC page number 515. Lahore High Court was pleased to declare the decision of GRC as illegal, and the company was blacklisted illegally, and the order was recalled, and it was declared that this is misuse of an authority by the procurement agency due to non-responsive. So the company's blacklisting order was set aside. And while announcing this judgment, while passing this judgment, Honorable Lahore High Court was pleased to rely upon PLD 2017 Supreme Court 83 and PLD 2010 Supreme Court 731. Another judgment is of 2021 MLD 1049 that no notice was issued by the Grievance Committee. This is also unfortunately a practice that favorable people are being awarded the contracts and the eligible deserving are knocked out on several grounds which are famous in our country, and this is the reason why the best agriculture country of the world and the most competent youth country of the world is so weak economically, and we are begging from the entire world. The country of Pakistan Steel Mill, the country of recording, the country of mines, I personally declare the most richest country of the world is our Islamic Jamhuriyat Pakistan, and God gifted, but due to these misrepresentations and illegalities and corruption, favoritism, nepotism, we are going down and down. Then PLD 2017 Islamabad High Court page number 115, principle is said that if notice is not issued, then again the order of GRC will be illegal. And then United Nations projects, this is what the most important thing that I want to discuss with you. I got stayed through a writ petition at High Court of Sindh Divisional Bench on World Bank's project, and that was I think 10 billion rupees project, or 15 billion project was that of World Bank. These biddings and these tenders were totally illegally and unlawfully passed, and I challenged that in the Honorable High Court of Sindh at Circuit Bench Hyderabad, and the Divisional Bench headed by my Lord Salahuddin Parmar Saab, another Honorable Judge, was pleased to grant stay in our favor, and the authority was directed to reissue fresh tenders and complete all the process transparently and honestly. So 2021 CLC 471 blacklisting was set aside in that United Nations project, and the 2021 CLC 1160 Islamabad High Court, the violation of rules 48, that opportunity of hearing was not afforded, that order of GRC was set aside, and the blacklisting of the company was set aside. Then 2020 MLD 185 Karachi, successful bidder did not prove his financial soundness, medical equipment, petitioner was aggrieved from the reward, and the award could create hazard to the public health. The writ petition was allowed, and that person who was eligible and was blacklisted, and the award was passed in favor of another person. It was challenged by the bidder who was disqualified, that due to unsoundness and other reasons, as it was a matter of medical equipment, so that tender could not have been awarded and that award was set aside. Then 2020 CLC page number 410 Sindh High Court said that post-contract alternate in terms is misprocurement and the petition was allowed. Some arrangements are being made. This is a practice that we unfortunately do not adopt the true procedure. In books our laws are top of the line. There's nothing wrong in our laws. The wrong is in the implementation of those laws. And then 2020 CLD 151 Islamabad High Court is that Companies Act bidding process is defined and pre-qualification clause 11 was violated and that writ petition